Hello, I'm Illinois State Senator Selena Villanueva, and I'm delighted to welcome you to today's panel discussion on the new movement for just cause employment. The problem of unfair and abrupt firings is getting long overdue attention around the country, spurred on in part by the pandemic. It has highlighted the very serious impact for workers and communities when workers lose their jobs. And it has also underscored the harms that inadequate protections against worker firings have on all of us, as we've seen workers who speak up about inadequate safety protections on the job being punished or fired. When workers aren't safe to sound the alarm about public health risks, none of us are safe. Those are some of the many reasons that, together with Representative Carol Ammons, I have introduced the Illinois Secure Jobs Act, which would give just cause employment protections to workers in Illinois. I've also been delighted to partner in this effort with the Raise the Floor Coalition and worker groups from across our state. Today's event couldn't be more timely. It brings together workers, policy advocates, and elected leaders to provide an overview of the new movement for just cause employment that has started to emerge across the country over the past few years. I really hope conversations like these will help spread the word that change is urgently needed to bring all workers in this country the secure jobs they need and deserve. Thank you very much.
Good afternoon, everyone. Welcome to our webinar entitled The New Movement for Just Cause Employment. I'm Rebecca Dixon. I'm the Executive Director at NELP, and I'll be your moderator for today. We at NELP here with our friends from the Roosevelt Institute are thrilled to host this conversation about the new movement for just cause employment. For the first time in decades, in response to worker organizing, there's a new momentum to rein in at-will employment. The fact that workers in the US can be fired at will with no notice or good reason and left with bills due and no paycheck causes extreme and unnecessary hardship for workers and their families. And the lopsided power that it gives employers over workers' livelihoods chills workers from speaking up about mistreatment. And that makes it difficult to enforce all of our important workplace rights and endangers the public. As with labor market inequities writ large, we know that Black and brown workers are harmed the most by this at-will system, since they are the ones who are most likely to be out of work for an extended time when they lose their jobs, and they have less household wealth to fall back on when they are out of work. And they're more likely to fear speaking up in the workplace in the first place about mistreatment or racial discrimination. That's why it's so exciting that we are seeing cities and states starting to replace the at-will system with just cause employment protections. Parking lot workers in Philadelphia, fast food workers in New York City, and journalists at many of our leading publications have all won just cause protections in recent years. Last month, Illinois lawmakers introduced the Secure Jobs Act, which you heard about at the top, which would extend just cause protections to all workers in the state. And a broad coalition of groups is urging President Biden to order just cause protections for employees of federal contractors. So we're really fortunate today to have a fantastic panel with us, a group of worker leaders, policymakers, and advocates that are going to tell us about this growing movement. So I will go ahead and introduce our panel. Just 1 second. So first, I would like to introduce Kate Andrias. She is a professor of law at the University of Michigan, where she teaches and writes about labor and employment law. And she recently published with Alex Hernandez and the Roosevelt Institute, Ending At-Will Employment, A Guide to Just Cause Reform. Next, Addy Baird, who is a political reporter at BuzzFeed News in Washington, D.C., and is the chair of BuzzFeed News' union. Next, Al Diaz. He is a griller at Chipotle in Manhattan and helped to pass New York City's new just cause legislation for the fast food industry. Next, Estrella Hernandez is a former staffing agency worker for SureStaff, Inc., where she labored in factories and warehouses. She is a leader with the Chicago Workers Collaborative and active with the campaign to pass the Illinois Secure Jobs Act. Next up, Brad Lander is a member of the New York City Council representing the 39th District in Brooklyn, and he is the co-sponsor of New York City's new Just Cause legislation for fast food workers. And last but not least, Irene Tung is a researcher here at the National Employment Law Project. Her research focuses on worker power, racial equity, and corporate accountability. She is the co-author of a new NELP report, Just Cause Job Protections, Building Racial Equity and Shifting the Power Balance Between Workers and Employers. And that was dropped in the chat for you all. So we're going to start our panel with our panel conversation, and then we're going to have a Q&A session where we'll get to hear questions from you, our allies in the audience. So please go ahead throughout the panel, submit your questions through the Q&A box. So important to put them there as opposed to the chat box. So we will just go ahead and launch right into it here. So I'm going to start with a question for Al. So Al, you were one of the Chipotle workers in New York City who fought and won a new law in your city council extending just cause employment protections to fast food workers. Can you tell us what led you and other fast food workers to fight for just cause? I think you're on mute, Al.
Can you hear me now? All right, so I've worked in fast food for quite some time now, after getting out the Marine Corps and the Navy. I've worked for Chopped, I've worked for Pret a Manger, and I'm currently employed right now with Chipotle. During my my fast food experience, I've had my share and of hearing and witnessing quite a few stories of how like fellow crew members have been fired unfairly, unjustly, and with very little notice. The story that really resonates, and I can still remember, is a Chipotle employer was fired for not smiling enough. You know, it's like also workers that complain about they would complain they would face reprisals. Like for example, I complain about more hours, and instead of getting more hours, management would reduce hours. I mean, instead of increasing them. What I'm trying to get to is like the impact of losing your job. It could be devastating. Let alone, you know, especially during the pandemic, I could be out of work for a month, maybe 2, maybe 3 months. You know, I couldn't fathom losing my job with short notice this time. How I'm gonna pay rent? How would I take care of my kids? I have kids. Let alone if I have child support. Like, by the time I figure this out, I'll be evicted. I'll be evicted by then. What I'm trying to get to is the impact that this has is it'll be brutal. It'll be brutal to workers, and it'll be brutal to workers and their families. That's what I'm trying to get to.
Thank you so much for sharing that with us, Al. Our next question is for Addy. Addy, many of us aren't familiar with the kinds of working conditions that journalists face. So how does being an AtWill employee versus having just cause protections change the job experience for you as a journalist?
Hi, thank you so much for this question. This is my favorite subject in the world, so I'm really glad to be here. Journalism is a very volatile industry, as I think anyone who pays even a passing attention to it can tell. There are layoffs very frequently. They tend to come out of nowhere. In my own short journalism career, I have lived through it more than once. And these concerns are compounded by the fact that ideas of what makes journalism good are very subjective. They vary editor by editor. They vary outlet by outlet. And so just cause protections were really important for our union. And one thing that's very concerning is that just cause protections are traditionally a very central piece to union contracts. When we started negotiating our contract, we got a just cause counter from management that included a loophole in just cause that would completely invalidate the entire existence of just cause in that contract. This loophole was essentially what they called an editorial loophole to just cause. They said any editorial work will not be subject to the 7 tests of just cause. This is crazy. Like, it's just flat out crazy. We're editorial workers. I was talking to a former flight attendant who works in labor who said that is like saying to a flight attendant, you have just cause except for any interaction that you have with passengers, which is their entire job. So this was very concerning for us. We also, very concerningly, saw this language at 8 tables who are currently unionized with the News Guild. I'm a member of the News Guild of New York, and we saw this at BuzzFeed, where I work. We saw this at the New Yorker. We saw this at New York Magazine. We saw this at Ziff Davis, Ars Technica, Pitchfork. I think I'm forgetting a couple, but it was not unique to us. And this was not something we were willing to move on. This is not something that we were willing to let go. For all the reasons I mentioned, this was a really vital piece of our contract. This was serious enough for us that we authorized a 1-day work stoppage. It was going to be a 24-hour walkout, and we did not walk out. I don't think it's a coincidence because we secured our just cause protection with no loophole the very day before. So this was a really vital piece of our contract campaign. It's something I don't think we should have had to fight for. And, generally, I think that one of the things that I spoke to a lot of journalists about is just there's an argument, I think, at times about just cause, particularly in journalism, particularly, like I mentioned, where you have subjective decisions about what makes work good, like I said. And the thing about at-will employment is it protects bad managers. Just cause does not protect bad workers. It simply gives you tenets to understand and have a due process with your employer. At-will employment protects bad managers who can fire you for any reason at any time. So that's a little bit about our story and why it was such an important part of our campaign.
Thank you, Addy. So we heard from Al and Addy that this is an important issue from industries as varied as fast food to journalism. So next up in our panel is a question for Australia. You've worked for many years as a staffing agency worker where you work for months at a time for an employer, and then if your job ends, you're assigned to a new job. In that context, can you share with us your experiences with unfair firing?
Sí, claro. Bueno, buenas tardes a
Yes,
todos.
of course. Good afternoon, everyone. My name is Hernandez. I am sharing my story because it's sad and unfair that from one day to the next, they can just fire you without letting you know and without giving you any kind of explanation. My family has really suffered as a result of that. For many years, I worked for a service staff agency for several companies in warehousing, and generally it was where there were several months of contract, and then I would be reassigned. But those companies and their staff didn't treat us with respect, and it wasn't rare that workers would be fired unfairly without being notified in advance. That's what happened to me. They hired me through Source Stuff to work during Christmas in a personalized gift factory. They told me that my work would last until Christmas, but then on the 8th of December, so more than 2 weeks before Christmas, I went to work exactly at 4 in the morning, and 10 minutes later, after starting to work, the supervisor got there and told me that they had fired me the day before. I asked him for the reason, and he said that he couldn't tell me anything about that I should ask the agency that hired me, Staff. And so they would tell me the reason. So I picked up my stuff. I went to the store staff office that was located in the factory. I waited for a representative to get there and I asked them for the reason for my firing. And he said they didn't have to tell me why. So it was frustrating because, including with my experience at that work, it didn't matter. It was not enough my experience for them to treat me fairly. I think the reason that they fired me was because on some occasions I talked about injustices, like one incident that happened a few days before. That day when I showed up for work with another workmate, someone talked about Mexican nationality using racist comments. And we talked about the shift leader, how we could report that. And we also asked the floor, we told the floor leader that the fabric wasn't obeying distancing measures. And I told them there were too many people working shoulder to shoulder and that we were training new workers constantly, temporary workers like me, and we didn't know if they were infected. So the government, the agencies and factories, they don't see temporary workers like us as important, and as we don't deserve respect, we don't deserve any kind of benefits, and they don't acknowledge that we're the ones who package their foods and to make their factories work. Losing my work without a notification was too much for me and my family. It was just before Christmas and it left me without work. It left me without money for a gift to my kids. I couldn't pay utilities or my rent. And it took me more than six weeks to find a new work. So it's really difficult to make it work with that kind of work, and losing it without being notified or any sort of reason, or it really puts us out to be vulnerable and poor workers like me. Because unstable workers mean unstable communities. Thank you so much.
Thank you so much for sharing that with us, Estrella. You can see from her comments that there are real consequences for workers when this happens, and not even giving you a just cause, just not even giving you the cause for firing you. Next up, for Brad, together with Al and the fast food workers of New York, you have won one of the first just cause laws in the United States. Can you tell us a little bit about the campaign and what you think that it suggests about the prospects for extending just cause to workers in all industries?
Thank you, Rebecca. It's wonderful to be here. I want to thank the National Employment Law Project and all the panelists, and really especially to Estrella and Al and Addy and all your coworkers who, it takes courage to lead a fight like this. So, this is really your leadership that's leading the way. New York City's new just cause laws, intros 1415 and 1396, which passed the city council in December, were signed by the mayor in January, and which will go into effect very soon in July, provide just cause protections for all fast food workers in New York City. That law is grounded in nearly a decade of organizing by fast food workers like Al and a lot of his colleagues, starting with the Fight for 15 strikes in November of 2012. At that time, fast food workers earned $7.25 in New York City, earned $7.25 an hour, did not have paid sick leave, had erratic and unpredictable schedules. Many were involuntarily part-time and had no protection from unfair firing. And so many reported, as Estrella and Al just have done, about being fired on a whim for no reason. But led by their organizing with the support of SEIU 32BJ and some really courageous worker leaders, every one of those things has changed since 2012. In 2013, those workers were part of a broad coalition that won paid sick days for all employees in New York City. In 2015, they won action for increases to a $15 minimum wage, first for fast food workers and then for all workers across New York State. In 2017, they won New York City's Fair Workweek law, providing 2 weeks advance notice of schedules and access to hours and full-time work for those who want it. And I want to flag this was a mix of city and state action. In New York State, cities are preempted from legislating on wages, so the minimum wage increase had to be done at the state level, but everything else, sick leave, fair work week, just cause, we were able to do through local legislation in New York City. All the other legislation has survived court challenge, so I'm confident our just cause legislation will as well. And then especially as the jobs got better as a result of all those steps, workers are more eager to keep them. But so many reported that they faced unfair firing. There was a survey of over 500 New York City fast food workers that showed 50% had been fired or laid off due to intolerable working conditions or unfair firing. 58% had had hours reduced. Most of those did not get any notice. 65% had not been given a reason for termination. And of course, that threw so many households into poverty as they lost those jobs. So from that experience and building on all that work we had already done together, we swung into action and developed the legislation. I'll drop both bills in the chat, but basically the two bills establish a good cause standard, require progressive discipline, require fast food employers to give a reason for any termination. They outline the pathways to secure those rights, which workers can do in court, through the Department of Consumer and Worker Protection, or through an innovative mediation approach. And the companion bill requires that any layoffs have to be done by seniority within the job title. So an employer can't call something a layoff that's really an unfair firing. We're really excited about it. It goes into effect in January. Congratulations to Al and all your colleagues. And just to conclude, at the same time that fast food workers were fighting to pass that legislation, Addy and her colleagues in the News Guild at BuzzFeed and the New Yorker, right in the same New York City neighborhoods, were fighting for just cause protections as well. And that led us all to this question: if fast food workers need just cause protections and journalists need just cause protections, really, who doesn't need just cause protections? And the answer that's emerging is everyone does. No one should be fired without cause or notice. At-will employment is not something that we need to keep accepting, and we should end it in all sectors. So I hope we'll be doing that by local law before too long in New York City, and that other cities and states, and through executive action, federal contractors, and someday through legislation, all workers in the United States will have the same.
Thank you so much for sharing that with us, Brad. Really, really inspired by the organizing of the workers and a long battle. So really inspired by that. So next question is for Kate, and I'm hoping you can put this in context for us more. So can you put in the US at-will employment system in context? How does it compare with employment in other countries?
Great. Well, thank you for having me. I'm really glad to be here with you today. There is no doubt that the US is an outlier. Nearly all other industrial democracies have a system of just cause employment. So to name just a few: Australia, Canada, Germany, the Netherlands, the UK, all provide just cause rights and prohibit unjust or arbitrary termination. And actually, even in the US, just cause is the norm for the wealthiest people and for people who have bargaining power. For example, the majority of CEOs in large publicly traded businesses are not employed at will. Their contracts specify that they receive compensation if they're fired without just cause, or their contracts limit the grounds for firing.
Well, that is, I guess, not a surprise when we know about the labor market inequities that we're experiencing here in the US. As a follow-up, could you take us through what the key components are of a good just cause policy?
Yeah, design is really important, because if policies aren't designed well, then in practice, workers aren't actually protected. There are a number of important elements, but I'll highlight three. First, a well-designed statute defines what just cause means with some specificity. So for example, it might make clear that for discipline to be just, the employee must have known of the work rule. The rule must have been applied consistently. Discipline must have occurred after a fair and objective investigation. It must be progressive, and reasons must be given to the employee for the discipline. A second important component is for the statute to place the burden of proof on the employer to show that there actually was just cause for the discipline. Because the employer is the party that has access to the greatest amount of information. It makes little sense to put the burden on the employee to show a lack of a reason for termination. It's important that the employer actually has to show there was a reason. And third, a well-designed statute should have sufficient remedies and enforcement mechanisms so that employers just don't ignore the law. And we see from other areas of employment law that when there are remedies and when there are enforcement mechanisms, employment law works, and when there aren't, it really doesn't.
Thank you for enlightening us on what we need to have in these laws if we're going to spread this good policy. Next question is for you, Irene. What does the research tell us about the prevalence of unfair firings and the impact of this at-will system on workers?
Thanks, Rebecca, and thanks to Al, Addy, and Andrias for sharing your stories. So unfair and arbitrary firings, like the ones that these panelists have described, are extremely common in this country. And the national data show that almost 1 in 2 workers in the US have had this experience at some point in their lives. And of workers who have been fired, the survey data show that 42% aren't given any reason for their discharge, and only 1 in 4 report being given a fair warning and a chance to improve before being terminated. But beyond the consequences for fired workers that we've heard about today, what's more subtle and equally harmful is how the at-will relationship fundamentally shapes power relations between the employer and the employee, creating an environment of fear in the workplace and driving down job quality, especially for workers of color. Our survey data also confirm this and show the measurable impact on workers of this power imbalance. So this slide, cue the slide please. This slide summarizes what workers report feeling pressured to do to avoid being fired or disciplined, including skipping breaks, working when sick or injured, working unwanted overtime, working extra hours without pay, putting up with verbal abuse, and working under hazardous conditions. So what we see is that the at-will relationship is the engine that drives a continual race to the bottom in job quality. So, where an employer can always say, oh, you're not willing to do that? Okay, I'll get someone else. And Black and Latinx workers report higher levels of these kinds of pressures than white workers. And this is one of the ways that the current at-will system reinforces racial inequity in the workplace. Black and Latinx workers of all educational levels report higher rates of unfair dismissals overall, suggesting that they experience racial inequities in at-will firings in many different kinds of jobs. 50% of Black workers and 52% of Latinx workers report having been fired or let go unfairly, compared to 45% of white workers. And on the issue of retaliation, the data also show that workers' fears are well-founded. Of workers who have been fired or let go, 1 out of 3 report that they were terminated for speaking up about problems on the job. So the picture that emerges clearly from the data is that the imbalance of power between employers and workers that is created by the at-will relationship is at the root of so many problems that we see in the workplace and beyond. It undermines basic enforcement of the minimum wage, health and safety protections, and laws against discrimination and harassment. And more generally, if we understand that the power imbalance between workers and employers is deeply implicated in both economic inequality and racial injustice in this country, then we really have to look to the role of at-will employment in producing that power imbalance. And so that's why it's critical to fight for just cause employment if we care about any of these things.
And Irene, as a follow-up, is there evidence of how transitioning to a just cause system would affect workers?
So the bottom line is that just cause give workers more individual bargaining power to make their jobs better and safer. And from recent studies, there are exciting empirical findings about the benefits of just cause, including how just cause can boost wages, especially for women and people of color, decrease injuries in the workplace, increase training opportunities, especially for workers of color, and even improve educational outcomes for children of workers.
De educación para los niños, para las criaturas de los trabajadores, entonces hay consecuencias más allá de en el área laboral, incluyendo los estudios.
And I think what's also important to remember is that the policy is also a vehicle to communicate and to move a change in cultural consensus in this country, sort of a cultural shift in how we understand this basic relationship between boss and worker as one of mutuality and respect as opposed to subservience. And at its heart, I think that's what this movement is about.
Very well said. So at this point, we're going to move into your questions. So the first question that we have is for you, Al. What sort of difference do you think the New York new law for fast food workers is going to make for workers like yourself and for employers?
First off, just cause laws will show employers that there are other ways to go about it. You know, before getting rid of a worker, before there are options. Also, the law prohibits fast food workers, or fast food employers, I'm sorry, from cutting workers' hours by more than 15% without just cause. This will protect us from unfair cuts, which is common in the fast food industry. It also requires employers to give workers advance notice of like any work problems and a chance to address them by providing them with training, adequate training, and also coaching if they need. And frankly, that's what better employers, that's how they operate right nowadays. It's not radical, and it shouldn't be a burden when this law comes into play. I think it's going to be in the summer sometime, but it shouldn't be a burden. Fast food workers, for fast food workers, this law, it would be tremendous. Right now, fast food workers are on pins and needles due to unjust firings. We're afraid that if manager doesn't like us or work ethic, we could be out of job by tomorrow, you know? And just cause law will give us security, it will give us a peace of mind. In case of if a problem does come up, there'll be a process and a chance to receive training. It's just the way to go. And that losing your job would be of a last resort. It's like a last option. As well, if there's let's say there's a bad manager at the workplace due to mistreatment or unsafe work conditions, employees they don't have to be afraid to speak up because they're afraid of in fear of repercussions. What I'm trying to get to is that just cause is just common sense. Like, it's sort of surprising that not many companies are following this already. It basically baffles me. It should be nationwide. Is that true? Not just New York, Jersey. It should be nationwide. Thank you.
Thank you, Al. And I agree with you. Common sense, right? It gives responsibilities for employers and really does create a better environment for workers. Our next question here is for Kate, and this is a two-part question, Kate. So how did at-will employment become the default form of employment in the US? So that's the first question. And then the second one is, how would enforcement of a just cause policy work? Can you kind of walk us through the nuts and bolts of how that would work?
Yeah, great. So at-will employment dates to the period after the Civil War, where there was a real debate in this country about what would it mean to really have free labor. And ironically, to some extent, the at-will employment doctrine comes out of this idea that workers should have the right to quit, right? Some very fundamental right that workers aren't required to continue doing a job when they don't want to do that. But judges then took that concept and through common law, through a series of decisions, expanded it to also create this doctrine that employers have the right to fire workers for any reason or no reason at all. So it dates to that period of the 1870s, and eventually by the early 20th century, by the 1900s, it became constitutionalized to the extent that the court repeatedly struck down democratically enacted legislation that protected workers' rights on the ground that legislation violated the liberty of contract. So those cases, the idea that there's a liberty of contract, that means that government can't protect workers, that government doesn't have the power to protect workers, that's no longer constitutional law. That was struck down in the period of the New Deal. But this at-will doctrine stayed with us as part of kind of the baseline of employment. So it really is part of this, this period of employment law that we've otherwise rejected, that workers don't have the basic rights on the job. So that's the historical origins. As far as the enforcement question, it's important. Enforcement is really critical. As I said before, legislation only works if there's effective enforcement. Ideally, there should be more than one route for enforcement. It's important that there's both a low-cost, kind of quick administrative mechanism, and also a way to proceed in court if the administrative system fails or is ineffective for some reason. And there's different ways to achieve that. Design can be different in different statutes. But for example, under the New York fast food just cause statute, a worker who's fired unfairly can file a complaint with an administrative agency, with the New York Commissioner of Consumer and Worker Protection, can pursue the claim through arbitration, or can file a lawsuit in court. So let's say the fast food worker decides to go to court. After they file the lawsuit alleging that they were terminated without just cause, the employer then bears the burden of proving by a preponderance of evidence that the firing was just. And at that point, the court considers all the evidence and things like, did the employee know of the employer's policy? Did the employer provide adequate training? Did the employer's policy, was it reasonable? Was it applied consistently to other workers? And was there a fair and objective investigation? And so there's a process of producing evidence. And ultimately, if the employer fails to show that there was an adequate and just reason for the termination, then the worker would prevail and would be entitled to reinstatement, as well as to damages and to reasonable attorney's fees and costs.
Thank you. So our next question is for Brad. And Brad, we're getting a lot of questions about just cause laws and sectors. And what folks want to know is, how would we go about expanding them to more sectors? And one of the examples that they raised was one around adjunct faculty and how little protection they have. So they want to know about that. And then, are there key sectors where you think it's there's a special need?
Absolutely. First, I'll just reiterate what I said before. You know, I have become persuaded that what we ought to be doing is trying to get wall-to-wall just cause protections there, because the flip side of that is like, which workers should be able to be fired on a whim without any cause or notice, and for no workers should that be the case. That said, it makes sense to build the strength of these laws through organizing work. We started with fast food in New York City because it was fast food workers who were experiencing unfair firings. It was fast food workers who organized together with their colleagues to demand change and came to us and said, we need this protection, work with us. And I mean, that's how this idea of, you know, what we are now calling co-governance or inside-outside campaigns is supposed to work. It's not in the hands of the elected officials to think which workers, you know, it comes from organizing. So that's just what I guess I would say first. I mean, as people start to organize, and if adjunct faculty are experiencing unfair firings, then absolutely, it's worth working with adjunct faculty to figure out how to end it. And you might look at different ways of doing that, right? Addy and her colleagues did it through a more, you know, I don't want to say conventional, but through a collective bargaining effort, through a union organizing struggle. And that's an appropriate way to pursue that for a particular single workplace worth of workers. Although in journalism, you're seeing right now, union organizing spread like wildfire. News Guild, I think, won 47 campaigns last year. So, but individual, you know, sectors of workers in a locality or a state, by all means, should be looking at, and I would say build the case, you know, that study that I referred to, that Center for Popular Democracy and I think Community Service Society and NELP did together, to give the data and show this is, we're hearing from a few people, they're organizing. And we
Para
did
ver los datos, como que, ok, estamos escuchando a las personas que están organizando en cierto sector, ya tenemos datos y pues es un problema en tal sector y queremos hacer el caso que es un buen sector para legislar. Y bueno, y luego también la pregunta es, ¿qué se puede hacer a través de leyes locales o estatales? Y luego también se lo puede hacer a través de contratos, lo que está haciendo el presidente Biden para ver si los contratistas federales pueden obtener protecciones a través
through contracting first before we had the power in a lot of places to do local or state minimum wages. So you might want to consider, this is what, whether a city or an other public entity in its contracting could say, we're going to require just cause for any public contractors. All of those are good ways to go as we keep building and building. And I really do think this is going to be a momentum. It's like it's a little bit of a riddle, when you say, well, if journalists need it and fast food workers need it, pretty quickly, in all the ways that Al is talking about, the common sense of it starts to make broader sense to people.
Thank you for that. Next question is for you, Irene. Can you speak to how unfair firings are a racial justice issue and how just cause laws can protect workers of color against unfair treatment on the job?
Sure. So as I mentioned earlier, the data show that Black and Latinx workers report higher rates of unfair treatment in the workplace. And some of that is overt discrimination, and some of it is related to structural racism, occupational segregation, and the fact that workers of color in general have less power in the workplace and in the labor market. So our current discrimination laws are severely limited, and most discrimination claims fail because you have to prove discriminatory intent. And there's been lots of psychological studies that have shown that most people, including jurors, are very reluctant to ascribe discriminatory intent to others. But they're much more willing to say that something is unfair than to say that something is discriminatory. But right now, unfair treatment isn't illegal. And so that's where just cause comes in. It gives workers of color additional legal avenues to address unfair treatment. And just as important, it gives them more power on the job, which is the key to tackling systemic racism in the labor market.
Thank you for that. Our next question is for you, Estrella. So how does the pandemic affect workers' need for protection against unfair firings? So really kind of bringing it back to the moment that we're in right now.
Bueno,
in my experience, right, when I worked in a warehouse, sweets, candy during the pandemic, when all of that started, I don't think anyone took it seriously how dangerous it was. Some managers didn't take it seriously, and the majority didn't respect the safety measures to slow the spread of this disease. And I think one of the reasons is that the majority of us who work in those warehouses with temporary workers, and for the owners, we're strangers and we're disposable. All they want us to do is go to work and produce. If someone got sick with COVID-19, they would just send them home without pay. If people got sick because we worked in that kind of warehouses without being able to distance socially. Workers were afraid to talk about those conditions, those unsafe conditions, knowing that we could leave our work if we did it. If we had protections against unfair firings, we would have been able we would have been able to talk and insist on our employers taking measures to keep us safe. What is clear to me is even though they call us essential workers, they don't value us. We deserve to be protected and respected. And one of the ways of doing that is protecting us precisely against unjustified firings. Thank you.
Thank you for sharing that. That is definitely a challenge that we've seen in this pandemic of not having workers be able to speak up when conditions are unsafe. And so this just cause is a part of that, on dealing with that. So here's a question for the panelists as a whole. So whoever would like to take this one, and maybe more than one of you would. NELP's survey data shows that without just cause protections, workers are afraid to speak up about discrimination, harassment, other violations of workplace laws. Is that something that you've seen in your workplaces? And particularly for the workers on our panel?
I'm happy to jump in here. Unfortunately, the answer is yes, like absolutely. I think in journalism in particular, obviously there was a major movement to talk about sexual harassment in the workplace recently, frequently at the hands of managers who are subordinated and who are abusing subordinates. Without just cause protections, it is much more terrifying to be honest about the treatment that you receive from your boss. And also, this isn't just a question of sexual harassment. This is a question of like verbal abuse, which is unfortunately not rare. And this is also a question of like a boss, you know, like Estrella and Al have mentioned, who will cut your hours for no reason, who will fire you for not smiling, who will, you know, say they don't like the way that you write. It's unfortunately very common.
Did any of the other panelists want to speak to this question?
I mean, I think on the question of sexual harassment, I mean, we know that sexual harassment is ultimately not about sex, it's about power, right? And that is what just cause is trying to address here, is the massive imbalance of power between managers and employers and workers. And so it really gets to the root of some of those problems. And, you know, as you mentioned, the survey data show very high rates of retaliation and very high rates of fear due to retaliation, you know, with workers. I think a third of women say that they would not report sexual harassment as a result of being afraid of retaliation. And you know, high rates of workers also say they would not report health and safety concerns because of fear of retaliation. And you know, and their fears are well-founded based on the high rates that we've seen. So.
Thank you for that. So on to the next question. This one's for Kate. We have a audience member wondering how just cause employment and mandatory arbitration might impact each other, if at all.
Okay, well, in a series of cases, the Supreme Court has held that employers can require employees to sign mandatory arbitration agreements. And that can mean that workers might be required to arbitrate their claims rather than to litigate them. But what they can't do is take away rights that, you know, those agreements can't take away substantive rights that state law or federal law provide. So even with a mandatory arbitration agreement, if a state provides for just cause rights, workers would have the right to vindicate those just cause rights. They just might have to do so through an arbitration system. The other thing that arbitration agreements can't do is take away state governments' rights or local governments' rights to create administrative systems to vindicate rights. So the just cause can still function very effectively, notwithstanding this doctrine that really is actually a terrible doctrine that's bad for workers' rights more generally and should be changed, but doesn't defeat, right, the goals of just cause.
And one other question, somewhat similar. So if a worker is enforcing their rights, we have a question about whether this means that they can stay employed, or does that mean that they would be terminated and then have to go through the process without the job?
It depends on how the statute is designed. But even in the ones that have been drafted so far, most of them have some requirement of progressive discipline. And what that means is that an employer can't jump right away to termination, except for egregious conduct. But so what that means is that there's kind of a system that is in place that ensures that workers are, not immediately terminated for minor offenses, for example, or for unfair offenses. Statutes could be written even more expansively than that, however.
Okay, that is helpful for us to know. Next question is for you, Brad. We have a question. If workers want protection from unjust firings, they're asking, why shouldn't they just form a union? Why should we do this through public policy?
So first, any workers who are in a workplace where where their rights are being violated, by all means, should organize together and form a union. That is not always easy to do, as we saw down in Bessemer. The forces that are arrayed against workers when they try to organize in so many cases make it extremely difficult. And that's true in fast food as well. There's a set of labor law that makes it hard for workers, even though the conditions are obviously being set by McDonald's and Chipotle and Burger King, to organize against the folks who are actually creating the conditions that they're providing. So, I think, but if we believe, I think this goes to, what we were hearing before from Kate and from Irene, that we're the outlier here. The US is the outlier, that we have at-will employment. I think, unfortunately, sometimes we get like this in America, where we just accept a thing that employers have won as natural. But at-will employment is natural. And in so many cases, it's not even really law. It's not that I think sometimes as I talk to employers in New York City, they thought, well, state law gives us the right to fire people for no reason at all. And I was like, well, no, it really doesn't. State law doesn't yet provide protections for workers, but that's not the same thing. So if we believe, as a matter of public policy, for workers in some particular sector, or for workers more broadly, and for workers in your city or your state, that folks ought to get a reason, have a good reason, have a process, have progressive discipline. That's a totally appropriate field of public policy. And that's why we decided to do it that way on fast food. And I think other folks are doing that around the country. That doesn't change the fact that it's great to organize a workplace and push for more rights. Once even if, I think fast food workers in New York City have some other things that they want as well. So there'll still be reasons to organize for unions, with or without just cause protections being provided by law.
Thank you for that. And we're getting close to time, so this may be our last question. And this is for Irene. Can you talk about how the Illinois bill limits the use of electronic monitoring to discipline and fire workers?
Sure. So, we have seen an explosion of the use of these new technologies to surveil workers. And Amazon is sort of the most well-known example of this, sort of tracking workers every second to the, very granular electronic monitoring of workers' movements and actions. And so, what we realized is that just cause legislation is a good place to address the harms of these kinds of new technologies, because those technologies can very easily undermine any kind of just cause protections that we put into place, because those technologies give employers the power to make just sort of a momentary pause on the part of the worker a fireable offense, or a basis for discipline. And so we really need to decouple the power of those new technologies from discipline and termination to make sure that that there aren't potential abuses that we're already seeing at Amazon and at other employers.
Thank you for that. So we are very close to time, you all, so we're going to wrap up. On behalf of NELP and the Roosevelt Institute, I'd just like to say thank you to all of you for joining us, and thank you to our panelists for coming in and being willing to share with us what some of the challenges are that you've been facing. We're very excited about the New York law, and very happy to see that journalists are getting this protection. As we heard this afternoon, unfair firings are common in our workplaces, and they're wreaking havoc on workers and their families. So reining this in is super important, and we need to have just cause protections. They are a common sense, as we heard one of the panelists say, practical solution to this serious problem. And I'm excited to say that for the first time in years, we're seeing a worker movement that's growing around this, and folks around the country are pushing for change. You can find more information on just cause employment and the movement, and that can be found with these new reports that we have talked about, and I believe were dropped in the chat from NELP and the Roosevelt Institute. If anyone of you is interested in exploring a campaign, whether that's a state or a city, please do reach out to NELP. We would love to help. And that concludes our webinar. Thank you so much for your time and attention.